Hello, everyone, and welcome. Welcome to another live edition of Employment Law Q&A. It's a half an hour out of your day where you get to ask an employment lawyer questions and get answers about your workplace problems and workplace difficulties. My name is Alex Lucifero. I am an employment lawyer. I'm the managing partner of Samfiru Tumarkin's Ottawa office. Again, here today to take your questions and help point you in the right direction if you're dealing with a situation at work. And really, it could be anything across the employment relationship. Whether you're interviewing for a job and you feel like you're being treated unfairly, or you're being offered employment and you're not sure about a couple of terms in your employment contract, or if you're having difficulties with your boss or with a colleague at work. Maybe somebody's treating you poorly. Maybe you feel like you're being bullied in the workplace. It happens lots. Unfortunately, I have to say it, but there are lots of difficult relationships, difficult situations in the workplace. They happen all the time, every single day. If that's you, or if you've been suspended from your job or let go from your job in any way whatsoever, maybe it's a temporary layoff or it's a termination, maybe your employer's made allegations against you. Again, at any point throughout that employment relationship, if you have questions, if you're not sure what to tell your employer or what to do in your particular circumstances, now is the opportunity to get your questions answered, to get some information and get some advice from an employment lawyer. Please go ahead and post your questions, whether you're watching on YouTube or on Facebook or on any other live stream. Go ahead and post your question. I promise you, over the next half an hour, I will get to your question and I will give you the answers that you need. A couple of pieces of contact information right off the top. We always start our segments with how to get a hold of us. If you don't necessarily want to ask your question online, if you're a little bit shy, a little bit bashful, you want to reach out to us confidentially, absolutely you can. It is completely confidential. You can first find our contact information and get a ton of information at our website, employmentlawyer.ca. That should be the starting point to get some information about your situation. We have a ton of articles, a ton of video clips and postings about every single aspect of employment law. The other way in which you can reach us is by email, and that is at help@employmentlawyer.ca. You see it on your screen right now, help@employmentlawyer.ca. Send us a quick email. Give us a summary of the situation you're dealing with. If you've been terminated, let us know that you've been terminated and give us a basic understanding of the circumstances. It doesn't have to be much at all, really. Just send us an email, explain your situation. I promise you, someone will get back to you if you email in. And again, we will get you the answers to the questions that you have, and we will get you the appropriate advice. Once again, for those of you just tuning in, my name is Alex Lucifero, employment lawyer, partner with Samfiru Tumarkin, LLP. Before we get to the questions, and please guys, go ahead and ask your questions. That's what I'm here for. That's why we do a live stream like this. It's to answer questions in real time. I promise, by asking your question, not only are you going to be helping yourself, of course you're going to be helping yourself, but I promise you, you will also be helping other individuals who are watching this, either live or at a future date. You will be helping other individuals that are in the exact same circumstances and situation as you. You are not alone when you're dealing with a workplace issue, whether that's a severance package negotiation, or again, you're being bullied or harassed at work, whatever the situation is. I promise you, you're not alone. There are plenty of others, hundreds, if not thousands of other individuals dealing with exactly the same circumstances. Not only will you be helping yourself, you'll be helping those individuals as well. Okay, first topic I wanted to get into today. When we do the radio show, and I do the radio show with the firm on a weekly basis, we have a little segment we call the Case of the Day. And I wanted to talk about a situation that I came across today. Very quickly, I'll be brief, guys, and if I see a bunch of questions coming through, I'll certainly give the questions priority. But before that, I did want to speak about this particular issue because it's a situation we see, unfortunately, far too often. And it's to do with something I had mentioned a couple of times already, which is effectively workplace disputes and basically bullying and harassment and what we call reprisal in the workplace. Just before I jumped on this live stream, I was speaking to a very nice young lady who unfortunately had been let go from her job after a couple of years. Now, in the legal termination, which happened very recently, I mean, just a few days ago, this lady had been dealing with a difficult situation at work. She was being poorly treated by her boss. Her boss was quite rude to her. He would oftentimes demean her in front of others and treat her very, very poorly, just in the manner that he spoke to her. This lady took that, unfortunately, to a certain degree. Certainly, an employee does not need to tolerate that kind of behavior in a workplace, but she kind of dealt with it as long as she could, to the point that she simply couldn't deal with it any longer. And just a few months ago, she ended up filing a formal harassment complaint against her boss, as she rightfully should have. Again, an employee should not be subject to any kind of abuse, any kind of demeaning treatment from an employer or from a boss. And an employee has a right to voice those concerns with her employer. So she spoke to her HR, she voiced these concerns. HR, to their credit, investigated the matter. And just a couple of weeks ago, she received a response that the investigation ultimately determined that this was not harassment in the workplace. Now, I don't think that investigation was necessarily correct, because from what I heard from this individual, I do think that there was a degree of bullying and harassment in the workplace. But further than that, and even more serious than that, the employer ended up letting this employee go just a couple of weeks later. Now, that is a major, major problem for an employer, because what that clearly demonstrates is that this employee was terminated as a result of having filed that complaint against their boss. That is what we call a reprisal. It's effectively a punishment for having voiced your concerns about a workplace issue, and that is illegal. Even if this lady's concerns were ultimately unfounded, and let's say legitimately unfounded, so let's say the investigator was correct in their determination, it doesn't matter. Even if the claim was unfounded, you cannot punish an employee for having filed a complaint, a harassment complaint against an employer, against a particular employee in the workplace. And that is exactly what this termination was. The employer was basically punishing this employee by letting her go because she filed the harassment complaint. So what that means for this particular employee, unfortunately, she's lost her job. However, what that does mean is she's going to be owed a significant severance package, despite the fact that she's relatively young and was only with the company for a couple of years. She was in a position such that her severance entitlements are still going to be significant, and several months of pay. We're not talking weeks of pay here when we're talking severance, we're talking months of pay. And again, this other factor that comes up, which is a reprisal. Again, this lady was punished for filing a harassment complaint against an employee, against another employee, and was terminated as a result. Again, that is illegal. An employer is not allowed to reprise against an employee in that way. This lady is going to be owed additional damages as a result of the way in which she was treated by her employer. And again, that amount over and above her severance entitlements can be very, very significant. And so this is a lesson for all our employees out there. Again, if you are dealing with a difficult work environment, if you're dealing with a bad boss or a difficult employee, do not hesitate to file a complaint. All it takes is an email to HR or an email to your direct manager or an email to someone with some degree of authority within the company, and explain that you would like to file a formal harassment complaint against this particular employee. That triggers an obligation on the part of the employer to investigate. And ultimately, whatever the determination of the investigation is, you should not fear as an employee any repercussions or reprisal from that. Again, the law protects you in a situation that it protects you against any reprisal in your employment. And for employers, any employers listening or tuning in, again, you have to be very, very careful how you deal with these kinds of situations. Again, even where a harassment complaint is ultimately found to be unfounded, is found not to have happened, you cannot punish the employee who filed the complaint. You have to leave them alone, effectively. Okay, let's get to the question, guys. I did have another matter I wanted to chat about, but again, the questions always take priority. For those of you just tuning in, this is an employment law Q&A. My name is Alex Lucifero. I'm an employment lawyer coming to you out of Ottawa, Ontario, answering questions across Ontario. And if you have questions from other provinces in Canada, go ahead and ask as well. We've got about 20 minutes left on the live stream, so please go ahead and ask your questions. I promise I will get to all of them. And there's a couple in the queue already, so we will begin. All right, first in line. Thanks very much for asking, Christine. Christine asks, I've been told I need to attend an IME. What should I expect? Excellent question, Christine. For those of you tuning in that don't know what an IME is an independent medical examination. An independent medical examination in the employment law context could come up in a couple of different scenarios. The first one is in the context of accommodations in the workplace. So if you have some physical limitations or even mental limitations for that matter, and your employer needs to accommodate you, sometimes the employer will request an independent medical examination in order to determine what degree of accommodation is required. The other scenario in which an independent medical examination comes up is with respect to disability insurance leave. And so if you're on a medical leave of absence and the insurance company that is providing disability insurance benefits has some concerns or has some questions about your medical leave, they do have the right to send you for an independent medical examination where a third-party doctor gets to examine you and ultimately come up with an opinion with respect to your particular circumstances as to whether you can or cannot work. Christine, really what you should be expecting as far as an IME goes is kind of a full medical examination with respect to whatever your particular condition is. If you are dealing with a mental health issue and you're speaking with a psychologist, then expect to do kind of a full examination in that respect. Or again, if you have physical limitations or if it's a physical issue, again, expect to go through a full medical examination, really kind of head to foot, so to speak, again, specifically with respect to your particular condition. You should answer questions honestly and be open to the examination. Don't be difficult with the examiner or with the doctor. That might actually make matters worse. Be honest and truthful and, really do the best that you can at being a patient who is undergoing a medical examination. At the same time, if you feel like anything is being inappropriate, if you think the doctor or examiner is going too far in their examination, don't be shy to say so. Use your logic, use your reason. If you are dealing with a workplace issue, Christine, and particularly if you are a non-unionized employee, if you're a unionized employee, listen, you should speak to your union about what's, about the independent medical examination. If they've told you, if your union has told you you've got to do it and you've got to go, then so be it. In the non-unionized sector, I do have to say, Christine, and again, this is coming from an employment lawyer myself who has done this now for a decade effectively. I don't see independent medical examinations really at all. They're very, very rare for employees. So I would want to know more about your situation. I'm wondering whether it's even appropriate for your employer to be asking you to undergo an independent medical examination. What questions does your employer have? What are they trying to figure out that your own doctor can't tell them? That raises some suspicions for me. So what I'd suggest, Christine, is if this examination is coming up and you have a little bit of time between now and then, let's have a chat. Let's figure out exactly what's going on here. Why is your employer asking for this? Again, is it an accommodation situation? Are you off on a complete medical leave of absence? What's the rationale here? Because I have to say, there aren't many circumstances in which it is appropriate for an employer to be asking for an IME. So, feel free to leave another comment, Christine, and provide some context. I'm happy to kind of revisit it. Otherwise, again, listen, send us an email, give us a call offline. Certainly more than happy to chat and get to the bottom of why you're being asked to undergo an independent medical examination. All right, let's keep going with the questions here. JC asks, I've heard you guys talk about getting codes changed on records of employment, but wouldn't Service Canada just deny the change given that a previous code has been submitted? JC 2004, not necessarily. No, Service Canada, in my experience, doesn't ask many questions. Whenever we negotiate a severance package and the employer ends up having to pay an additional amount of money to the employee, which is very often, if not always, the case, the employer does also have to issue a record of employment whenever they pay an additional amount. And again, if, for example, an employee is terminated for cause, but there is no cause for termination, the employer made unjustified complaints about the employee's conduct or their behavior or their performance, and we can get a revised record of employment, oftentimes that does the trick really without question from Service Canada. So no, actually, there might be rare situations where Service Canada kind of looks into a matter further and has further questions, but I would say for the most part, JC, I don't hear boo when we get a record of employment changed and that allows the employee to, for example, receive employment insurance. I really haven't heard any issues from employees in those circumstances and any issues from Service Canada. So I wouldn't be overly worried about that. Listen, every situation is different. So if you're dealing, JC, with a particular situation, again, let's have a chat about it, and we'll obviously give you our objective, honest advice. But again, changing records of employment is something that actually we do quite successfully very often, particularly in situations where, again, an employee has been incorrectly terminated for cause, right? And they haven't been offered any severance. The employer has made inadequate allegations of, again, misconduct or poor performance. We can oftentimes get updated record of employment indicating that it is a without cause termination, and that allows the employee to receive employment insurance, which is a huge benefit, of course. So appreciate the question, JC. I know you're I've seen your questions before. You're certainly a long-time viewer, so appreciate you tuning in. All right. Another question here from Susan. Does my employer have to let me take a mental health leave? I've submitted a doctor's note but was refused. Thanks for the question, Susan. That is a major problem, in my opinion. To answer your first question, or to answer your question, Susan, absolutely an employer has to allow an employee to take a mental health leave. And quite frankly, they don't need to know what kind of medical leave it is, whether it's related to, your mental health or a physical ailment. A doctor's note doesn't have to specify. Your employer doesn't have the right to know what particular medical issue you're dealing with, whether it's mental or physical. All your employer needs, and all your employer really has the right to ask for, is a prognosis, meaning how long are you going to be off for. So Susan, if you submit to your employer a doctor's note that says, medical leave of absence for 2 weeks, guess what? Whether it's related to your mental health or not, your employer has to respect that doctor's note. If they terminate you in the response, if they try and refuse the leave in response, which it seems they have, those are major, major problems for an employer. That is discrimination under the Human Rights Code in Ontario. And our other provinces in Canada have very similar, if not the exact same kind of legislation, where that is an employer discriminating against an employee on the basis of their health, on the basis of their medical status and ultimately disability. And that is going to cost an employer dearly. Susan, if you wanted to, you can treat your employment as terminated if they've rejected your doctor's note, seek severance from the employer, and not only seek severance, but also seek additional damages for discrimination, for a human rights violation. You can be owed significant compensation in that situation, particularly if you're a longer-term employee, if you've been with the company for a while, if you're an older employee, and depending on your position, your severance entitlements are going to be significant, certainly. And then again, you'll be owed additional damages for human rights because your employer has incorrectly, illegally refused you a valid medical leave of absence, again, because you had a doctor's note. Now, I do want to specify, everyone, when you're taking a medical leave of absence, or when you need some degree of accommodation in the workplace. If you are dealing with, again, a physical issue, or even if it's a mental issue, and your doctor is telling you that maybe you can, or maybe you need more frequent breaks during the day, or maybe you can lift, only pounds or 10 pounds or something like that. Maybe you have, again, physical limitations. It's very important to note, you need a note from your doctor confirming so. Your employer does not need to take your word for it. It's not enough for you to say, I need time off for mental health reasons, or I can't do this for physical reasons, or I can't do that because of my physical limitations. Again, your employer doesn't necessarily have to take your word for it. You need a doctor's support. Make an appointment with your family doctor, get a brief doctor's note. It doesn't have to go into any great level of detail. It could simply specify either the amount of time that you need to take off, could be a couple of days, could be a couple of weeks, it could be a couple of months, could be longer than that, but it needs to be specified in a doctor's note. Or if we're dealing with accommodations in the workplace, again, maybe you're limited in terms of the number of hours you can work a day, or you're limited into what you can do and what you can't do within a workplace. Again, you need your doctor to confirm that in writing, in a doctor's note. Provide that note to your employer. They have to respect it. Don't let your employer take advantage of you if you're dealing with a medical situation. Again, whether it's mental or physical, your employer cannot push the limits there. They need to respect the doctor's note. If they don't respect the doctor's note, give us a call right away. Send us an email, visit our website, email us at help@employmentlawyer.ca. An employer has to respect medical accommodations and medical leaves of absence as long as you give them a doctor's note that says so. All right, next question, and we've got about 9-10 minutes left, guys. So if you're just tuning in and you want to ask a question about your employment situation, go ahead and ask. We'll do kind of rapid fire for the last 5 minutes or so, but in the meantime, I'll keep going with the questions. Thank you, everybody, so much for asking. Teresa asks, is it possible to get your salary back if your employer reinstates your job after being placed on unpaid leave for non-vaccination? Teresa, if you accepted the unpaid leave, and I say accepted, of course, almost loosely, because even you probably accepted it begrudgingly, it becomes very difficult to get that pay back. Your better course of action might have been to treat the unpaid layoff as an actual termination, which it may very well have been, to treat the unpaid leave as a termination. And at that point, you're seeking severance for that time period. So it's not necessarily a question of lost wages or unpaid wages. It becomes a question of severance from the date of the unpaid leave, which is the date you're considering kind of the termination of your employment. The reason why you may want to consider it a termination when you're dealing with an unpaid leave is because most, if not the vast majority of employers out there actually don't have the right to put employees on unpaid leave of absence. It's not a right that employers have by default. And so almost always when an employer puts an employee on an unpaid leave, which is basically like a layoff, we can call it, that is a breach of contract. Again, the employer didn't have the right to do that inherently. And so you can treat that unpaid leave as a breach of contract, which is basically a termination of employment, and then seek severance. Teresa, again, if you accepted the unpaid leave and kind of wanted to stick around on that unpaid leave until you were called back to work with respect to being not vaccinated, then again, I think it becomes and you've been called back, then again, it becomes very difficult to kind of treat that unpaid leave of absence as a claim for lost wages. Teresa, listen, your situation is probably a little bit more complicated than what I just described. My suggestion to you, if you haven't already, let's have a chat. Whether it's with myself or any one of the other employment lawyers at our firm, I promise you we will give you the correct advice. We will point you in the right direction. We will tell you what arguments you have in your favor. And so give us a call. Again, visit our website. You can contact us through our website, employmentlawyer.ca, and we'll get you on your way to knowing what your full rights and entitlements are. All right, AJ asks, is it true that LOA, I'm assuming you mean leave of absence, is not considered constructive dismissal under IDEL? Does common law override this? AJ, excellent question. You're using legalese language, which I love because you clearly understand what's going on here. I'll fill in the listeners. What AJ is referring to is a leave of absence under what's called the IDEL or IDEL, that's infectious disease emergency leave. What this effectively is a temporary layoff that's COVID related. So what AJ is asking, and it's a great question, is a temporary layoff as a result of COVID a constructive dismissal, basically a termination of employment? And does the common law, meaning our judge-made law here in Ontario, override this? AJ, we have a couple of cases out of the court in Ontario, and actually one that just came out of the Court of Appeal, which confirm that a layoff, even if it's a result of COVID-19, can still be considered a constructive dismissal and therefore a termination of employment, in which case the employee is, of course, going to be owed severance. So the answer to your question is common law does override the IDEL, AJ, although there might be a couple of exceptions. Keep in mind that if you have an employment contract, a written employment contract, that allows the employer to lay you off. So if you look at your employment contract and you see in that contract a paragraph that says the employer is allowed to lay you off in accordance with the Employment Standards Act, then your employer may still be allowed to put you on temporary layoff, even if it's related to COVID. So the devil is always in the details. But I would say, AJ, for the vast majority of employees out there, yes, you are entitled to claim constructive dismissal, even if the temporary layoff or the infectious disease emergency leave, as they've been calling it, is related to COVID. If you haven't already, again, let's have a chat about it off air, get into the nitty gritty of your particular circumstances. And again, you may very well have some options here. All right, let's keep it going. Baha asks, why still some employers and workplaces still require new hires to be vaccinated? However, the province has lifted the mandatory vaccine. Is there a law? Are we having different laws? It's a great question, Baha, and it's an unfortunate one because I probably have to agree with you. At this point in time, given kind of the state of COVID in Ontario, at least, I find that a vaccine policy that requires employees to be vaccinated without any alternative options available is probably overreaching. It's probably an unnecessary term of employment. Now, and for the reasons that you mentioned, with all of the mandates lifting and while all of the health and safety, masking and whatnot lifting in the province, it really doesn't make sense for employers to be very strictly enforcing these vaccination policies for new hires and for existing employees as well. That said, I do have to say there's nothing inherently wrong with an employer doing that. They can certainly implement a vaccine policy for new hires, I want to be clear, without any real legal recourse for those particular prospective employees. That said, I also want to make clear that for existing employees, if you have been terminated as a result of not being vaccinated, or if you've been put on unpaid leave as a result of not being vaccinated, you do likely have recourse in a situation like that. And so if you're in that situation, if you're being put on unpaid leave, or if you've been terminated without an appropriate amount of severance as a result of not being vaccinated, again, give us a call, send us an email, get a hold of us any way you can. Because it's certainly worth a conversation. Do not just walk away from your employment, or do not just implicitly accept the unpaid leave if that's the situation you find yourself in. We'll squeeze in one more question here from Carrie, because it is a long-term disability questions, and I like these questions as well. They're employment related, of course, but they have to do with disability insurance. We'll try and do this rapid fire. Carrie, thanks for your question. I was told that I'll be cut off from my LTD on leave for depression and anxiety. The insurance company was apparently spying on me and said that I'm able to go back to work based on my recent activity. Carrie follows up in another post. I was at a family gathering recently, which is the only thing I can think of that would have given them this opinion, but I'm still on medication and going through counseling. What can I do? Carrie, this is an intimidation tactic by the insurance company. They allege, or they may very well have been spying on you and tracking your movements and tracking your daily activities, and are now cutting you off as a result. Listen, it comes down to this, Carrie. as long as you still have the support, whatever activities you are doing, as long as you still have the support of your doctors and of your treating physicians, it could be your family doctor, it could be a psychologist or a counselor, as long as they continue to support you in being unable to work, you should continue to receive disability benefits. If you have your doctor's support and they confirm that you're still not able to go back to work, but the insurance company is cutting you off, give us a call right away. You want to jump on this right away, Carrie. Don't let any time pass. Email us at help@employmentlawyer.ca, or again, visit our website, employmentlawyer.ca. Let's have a chat, because I promise you what the insurance company is doing, if you have your doctor's support, is wrong. You are owed those disability benefits. We will leave it at that. Everyone, thank you so much, everyone, for tuning in. I hope you found it informative. Have a great rest of your weeks, and we will talk again soon. Until then, signing off. Take care, everyone.